malice, है ना? So when the basically the law is used to harass someone with the malice intention, that is called as malicious prosecution, in which what happens is, for example, there is one party and this party institutes a criminal proceedings, okay, in the court of law against another party. Okay, now this plaintiff basically starts a criminal prosecution against the another party, due to which what happens, ultimately this person is proved innocent, and later on he was the defendant in this case, he is proved innocent, and here what happens now, he found that this proceeding was instituted against him, this proceeding was instituted against him by this party on malicious grounds, okay, with using malice. All right, so now what he do is, he now becomes the plaintiff and starts the proceeding against B, because he must be compensated, because compensation must be given to this plaintiff now, because he is now the plaintiff, so he must be given the compensation because he was harassed using the law, using the judicial machinery, using the rule of law, okay, using the code. He is basically harassed, so he must be entitled to compensation. All right, so malicious prosecution is the wrongful use of the लीगल प्रोसेस. ओके, तो ये प्रोसेस का, इसमें क्रिमिनल प्रोसीडिंग इज देयर फ्रॉम ए अगेंस्ट बी, in which there is no reasonable cause, no probable cause, with malicious intention, and basically this ends in the favor of the plaintiff, who is now the plaintiff in the criminal prosecution, who was earlier the defendant. Now it turns out to be in favor of this person. Now this person starts the malicious prosecution against that person who first instituted the criminal proceedings against this person. All right, now we saw that there are certain elements, certain essential ingredients of malicious prosecution. These are, to succeed in this, the plaintiff must prove that earlier the criminal proceeding was instituted by the plaintiff and now he will become the prosecution, and then this malicious prosecution must be instituted or initiated by the defendant, who was in this case defendant, and now he will become the plaintiff, right? Now he must prove that there was absence of any reasonable and probable cause. The malice was involved in this. There was malice, and the proceeding terminated in his favor, and there were damages. So he is entitled to compensation. All right. Now we saw that in this West Bengal State Electricity Board case, okay, against Dilip Kumar Rai. So in this case, we got to know that what happened. West Bengal Electricity Board instituted a case against whom? Against Dilip Kumar Rai, who was the employee of under this board. Okay, and the case was that the West Bengal Electricity Board, they charged Dilip Kumar Rai with basically some wrong thing, okay, some wrong that is done by him, and in turn suspended him from his job. Okay, and what happened, the Bengal High Court, so what was done by the Bengal High Court, the Bengal High Court found that this proceeding, this suspension was wrong, and instituted damages. Okay, but ultimately in this case the Supreme Court, because this case can reach till Supreme Court, and Supreme Court, what Supreme Court did was, Supreme Court basically gave some principles, that those principles are till the present time used as the principle to check whether a proceeding can be, a malicious proceeding can be instituted against any person or not. We have already seen this case, and the essential ingredients that were put forward in this case were that there must be absence of reasonable and probable cause that led to the harassment of the person, damage to the person, for which the person is entitled to get compensation. All right. Another thing is that the proceedings terminated in favor of the plaintiff, and now the plaintiff is starting the proceedings of malicious prosecution against the another person. All right. What is the meaning of malice? We understood this thing, that the meaning of malice is somewhat improper motive, some wrong motive. Okay, it means that there is some indirect or improper motive involved in this case. All right. So now we know that there are certain elements that the prosecution must be now. So for example, A instituted a criminal proceeding against B. Now B, here the proceeding ends in favor of B. Now B becomes the plaintiff and now B starts the malicious prosecution against A. So in this case now the malicious prosecution must be started by the defendant and this defendant must start this malicious prosecution. Another essential element is absence of reasonable and probable cause. Malice is there and the proceeding terminated in favor of the plaintiff and basically damages are entitled to the plaintiff. We understood the first one, second one, okay, and now we are on the third one. We understood the third one, but just have to write that, okay. So just write what is the meaning of malice. What is the meaning of malice?
सर ये लिखा दिया था आपने. What is
Have
the
I made you
meaning?
right?
Yes.
Okay. So now write the next one. Write the next essential ingredient, that is termination of proceeding in favor of the plaintiff. Okay. Now, in this case, we are talking about the first one of the first case, okay, the earlier case. So, where A, who was the plaintiff, he started a criminal prosecution against B, wherein A was the plaintiff, B was the defendant. Now, defendant is proved guilty, and this defendant becomes the plaintiff and starts the the malicious prosecution case against A. Now, this defendant who was earlier defendant now becomes the plaintiff and now who was earlier the plaintiff becomes the defendant in malicious prosecution, right? So here it means that the proceedings terminated in favor of the plaintiff. That means earlier the criminal proceedings ended in the favor of the plaintiff. The case must not end in conviction of the person. The case must end in favor of the person who now is going to start the proceedings for malicious prosecution. All right. The core principle is that if the plaintiff is convicted, no action for malicious prosecution can be there. What is the meaning of favorable termination? That is, proof of innocence must be there. The person who was in the first case charged, now he must be proved not guilty. There must be proof to prove his innocence in this case. All right. So when is it favorable? When acquittal happens. Technically, acquittal means the person is proved not guilty. When discharge of accused, the accused who was charged, now he is discharged of all the charges. When the case stands to be dismissed, when the prosecution is then withdrawn, and when the conviction, even on the appeal, the conviction which was earlier there now is quashed. All right. In these cases, the person who now is proved not guilty can institute the proceedings of malicious prosecution against the another person. All right, got the point? Now, what is the effect of appeal? So, the effect of appeal is that earlier it was held that the initial conviction, if there is only initial conviction and not the proof of innocence, then also the malicious prosecution proceeding can be started. But now the modern view is that the plaintiff can file the suit. And a very important clarification is that acquittal thus is not just enough. There must be of malice and there must be proof of the absence of reasonable cause. All right, there must be proof that there was no cause, no reasonable or no probable cause when the A% plaintiff started the criminal proceedings against the B defendant. All right, so these things must be suited, these things must be at place, and now just start writing. So just write put the heading termination of proceedings in favor of the plaintiff. Give me a second. I think there is some network issue. दीपू ये हैंग हो रहा है, वहां चल रहा है क्या? रहे हैं। तो यहाँ कुछ फैन की जरूरत है क्या? Okay. So yes, right. The plaintiff must prove that लिखो ये plaintiff को prove करना होगा. The plaintiff must prove that the earlier criminal proceedings which were instituted against him, the earlier criminal proceedings which were instituted against him has ended in his favor. Has ended in his favor. This must be proved. All right, this must have been proved. Okay. The case must not end in conviction. As simple as that. The case must not end in conviction. All right. There must have been no conviction in the case. Okay. Right. If the plaintiff, sorry, ऐसे लिखो. If the defendant in the earlier case, who is now the plaintiff, is convicted, malicious prosecution cannot be initiated. Cannot be initiated. And therefore conviction is a complete bar. Conviction is a complete bar. Okay. That's right. What does favorable termination means? What does favorable termination means? Now, what is the meaning of favorable termination? Right? It does not means the proof of innocence. It does not means the proof of innocence. Rather, it means no judicial findings of guilt. It means no judicial findings of guilt. Okay. Guilt couldn't be found. It means absence of guilt. Right? When is termination considered favorable to the defendant? When is termination considered favorable to the defendant? Right, these points. In case of acquittal, even on technical grounds. In case of acquittal, even on technical grounds. Then right, when the discharge of accused happens, when the discharge of accused happens, also right, when the case is technically dismissed, when the case is technically dismissed, all right, when the case is technically dismissed, when the prosecution is withdrawn, when the prosecution is withdrawn, or the conviction is quashed on appeal, or the conviction is quashed on appeal. Okay, and when the conviction is quashed on appeal. All right. You can also write what is the effect of appeal. Now, for example, just understand. Now, just imagine. Now, A has started a criminal proceedings against B. Now, B is proved to be not guilty. Okay. Now, B wants to initiate the malicious prosecution against A. Okay. Now, in this case, if already A goes for higher appeal, then during that time can B initiate the proceedings of malicious prosecution? So, right. What is the effect of appeal? What is the effect of appeal? Right. Earlier in Reynolds versus Kennedy case, Reynolds in Reynolds versus Kennedy case, it was held that initial conviction, yeah, in case of initial conviction, the defendant cannot take the action of malicious prosecution even if the conviction is reversed later on appeal. Okay. In the next point, right? But in the modern and more accepted view, if the conviction is reversed later, the plaintiff is entitled to file the suit for malicious prosecution. Malicious prosecution. Now, again, coming on to very important thing, that is damages. Okay, so this is another essential ingredient of malicious prosecution, that is damages. All right, so now just understand this, like if for example, now again coming back to the topic of malicious prosecution, there is A, that is plaintiff basically without any reasonable cause or probable cause with malice initiates a proceeding against B. Now in this case, B is the defendant. Now B, the proceedings terminates in the favor of B. B is held not guilty. Defendant is held not guilty. Now B here becomes the plaintiff and files a suit against A. Okay, that is the malicious prosecution suit. For this, there must be certain damages that have been suffered by this person, because A has initiated a criminal proceedings against B with malice. without reasonable and probable cause, now it is required that B must have suffered with certain damages. There are certain damages being suffered by this person. All right. So that is, this person must have suffered certain actual damages, real damages. Damage is the gist or the core of the action. For these damages only, the proceedings of criminal prosecution will be initiated. All right. Now, the how the damages will be assessed, it will be by the nature. What the accusation was, of what nature? Was it of a defamation nature, or basically of what nature? Degree of harassment, how much this particular person is harassed due to the malice or prosecution that was basically initiated against him. All right. Now, what kind of financial loss he has occurred? Okay. It is based on common sense and also on the basis of the circumstances surrounding that environment during the time when the case was filed on malicious grounds. Okay. Now, in the Sova Rani Datta versus Devrat Datta case, it was said that in case of false FIR, the plaintiff was handcuffed, and because of this handcuff thing, the plaintiff has suffered humiliation, and due to this humiliation, the plaintiff must be compensated. All right. So damages to the plaintiff if happens, so real damage must be there. Yes, so damage must be in real. All right. So write this. What was the last thing we have written?
सर लास्ट में तो वो फोर्थ वाला पॉइंट ही जस्ट
Okay.
कंप्लीट करा
Now
था.
give the fifth essential ingredient, the fifth major point. Right? Damages. So damage is essential, and without the damage, there can be no claim, and even it can be financial damage, it can be physical damage, it can be reputational damage, damage to the reputation, or any kind of damage that can happen. All right. So just write this. It means the plaintiff must prove that he has suffered actual damage due to the prosecution. Right. In Muhammad Amin, Mohammad, in Muhammad Amin, Muhammad is spelling. Amin versus Joginder Kumar case. Versus Joginder Kumar case. Joginder Kumar case. It was held that the test to check the test is whether the proceedings has reached a stage where damages is possible. Where the proceedings has reached a stage where damages is possible or not. Possible के साथ में in bracket you can also write the word occurred. Damages has occurred or not, है ना? And therefore we can conclude that Therefore, we can conclude that mere filing of complaint is not enough. That mere filing of complaint is not enough. Okay, mere filing of complaint is not enough, and damage must actually result. And damage must actually result. All right, the damage must actually result. Okay. So there was a case that was Saville versus Robert case. Put a heading types of damages and write in Saville versus Robert case, the court highlighted that there are three types of damages. There are three types of damages. Okay. अच्छा मयंक, someone was asking me उसमें जब when you got yourself enrolled for the BCI तो उसमें कितने advocates के साइन जो है अब लगते हैं आजकल?
तो सर
BCI में enroll करने के टाइम BCD में बार काउंसिल ऑफ दिल्ली में how many advocates signature were required there?
सर मेरे केस में तो मतलब मैं एक भैया को जानता था, उन्होंने एक सीनियर एडवोकेट के साइन करवाए थे मेरे
एक ही के में
डॉक्यूमेंट्स
हो गया
में।
था?
हाँ, एक ही के लिए करवाए थे साइन।
अभी someone was asking me, one student was asking कि उसको कराना था, was like कि ने जो है how many signs एक ही में, चलो तो देख लेंगे। अच्छा, so right, so this was the case Saville versus Robert case. Here the court highlighted that there can be three types of damages. ठीक है, एक तो damage to the reputation. The first damage can be damage to the fame, है ना, जो fame होता है लोगों का. फिर the another can be the damage to the person, can be the damage to liberty and the mental suffering of the person. Mentally उस person as a whole को suffer हुआ. And the third type of damage can be financial or property damage. All right, so just write the first damage to reputation or fame. Damage to reputation or fame. Okay, so just write false criminal charges can harm. False criminal charges can harm the social image, of a person, and especially the damage can be of a greater magnitude if the charges were grave. If the charges were grave, ठीक है, अगर charges grave हो तो damage can be much more. All right, and also example of damage to reputation can be social stigma, right? Social stigma, from a loss of respect, etc. Now write the second type of damage, that is damages to the person, and even in bracket you can write mental sufferings and liberty. Can damage the liberty of the person also, है ना? Can damage the mental, the person can face the mental sufferings also. This can also be a type of damage only, right? You're right. It includes arrest. If you are arresting someone, then you are restricting the personal liberty of that person. Okay, comma detention, arrest, comma detention, comma physical inconvenience, and mental stress and humiliation. Mental stress and humiliation. क्या हुआ? इसमें तो कोई नहीं है ना अपना, मेरा तो वहां चल रहा है ना क्लास। हाँ, इसमें कुछ प्रॉब्लम है। बोलो एक बार, मेल करो एक बार। Also write examples like handcuff and public embarrassment. Handcuff and public embarrassment, है ना? से हो जाता है। Right in the Savarani Datta versus Debabrata Datta case. Debabrata Datta case. It was held that false FIR. False FIR. In this case, it was held that false FIR caused the handcuffing of the plaintiff, and due to this, compensation was awarded to him for humiliation. Compensation was awarded to him due to humiliation. Now write the third type of damage, that is damages to property, and in bracket you can write financial loss. And in bracket you can write financial loss. All right, you're right. Right, it includes legal expenses. Okay, loss of income, comma, cost of defense, and an example you can write the lawyer's fees, travel expenses, etc. Okay, write a question, how to assess the damages, yeah, how to do the assessment of the damages, yeah, how to assess what damages has happened, है ना? Assessment of damages. तो देखो कोर्ट कंसिडर सेवरल पैरामीटर्स, है ना. So those parameters are basically the nature of the charge, okay, the graveness of the charge, the degree of harassment that has been faced by the person, you know, financial loss that is he has incurred, okay, the damage to the status and reputation of the person due to facing that charge, okay. So just write. So for the assessment of the damage, the court for the assessment of the damage, the court takes into consideration the court takes into consideration several the court takes into consideration several factors like the nature of the accusation, like the nature of the accusation, comma, degree of harassment, comma, degree of harassment, comma, financial loss, financial loss, and the loss to the status and reputation of the plaintiff, the loss to the status and reputation of the plaintiff. And also write, this assessment is generally based on this assessment is generally based on common sense and the circumstances is generally based on the common sense and the circumstances surrounding it. Okay, so it is generally based on the common sense and all the circumstances that are surrounding it. Okay. Now the one topic that is left is basically false imprisonment. All right. Now the main objective of these classes is to draw the distinction between malicious prosecution and false imprisonment. All right. And here what you have to do is, so we will be continuing with now understanding what is false imprisonment. And when we will be over with studying the false imprisonment, then we will be coming on again to this malicious prosecution, and then we will differentiate between malicious prosecution and false imprisonment. All right. So now let's come to the topic that is false imprisonment. Okay. So just give me a second.